sunny Thursday in 1967, Vincent Fagan was driving his car down a street in northwest London, when all of a sudden... "Oh golly," said Vincent. Police Constable Morris didn't like how Vincent had stopped and pointed to a place by the curb. Vincent moved his car up and parked in that very spot. Unfortunately, he also parked on the policeman's left foot. "Get off! You're on my foot!" cried Constable Morris. "Just a minute, Constable," said Vincent. Although Vincent eventually reversed off the policeman's foot, he was convicted of assaulting a police officer in the execution of his duty. Police Constable Morris suffered a swollen and slightly bruised big toe. Poor Constable Morris. The issues. At common law, the necessary intent to commit a crime, or mens rea, and the prohibited conduct, or actus reus, must normally coincide in order for an offence to be proven. On appeal, Fagan tried to argue that the prosecution had not proven the elements of the assault charged, as his mens rea did not manifest itself until after the actus reus of rolling onto the officer's foot. Therefore, there was no positive act on his part which could constitute an assault, but only an omission or failure to remove the wheel as soon as he was asked. The issue before the court was whether his conduct could form the basis of the actus reus required for assault. The judgment. The court confirmed the general principle that a mere omission to act cannot amount to an assault. Justice James, writing for the majority, held that mounting the policeman's foot with his car was initially an unintentional act, which was later converted into an assault by his purposely delaying the removal of the car. That is to say, his failure to move the car was not an omission, but rather a positive act in allowing the car to remain in place. Although the initial application of force was accidental, the offence was complete at the moment the necessary intention to continue to inflict unlawful force was formed. In dissent, Justice Bridge disagreed with this characterization of Fagan's conduct as a continuing act. His lordship asked, after the wheel of the appellant's car had accidentally come to rest on the constable's foot, what was it that the appellant did which constituted the act of assault? However the question is approached, the answer I feel obliged to give is precisely nothing. This case illustrates the importance of how the relevant act is defined as to whether it can be characterized as an assault or a mere omission. As we've seen, this is a matter on which reasonable minds may differ, and the outcome is wholly dependent on the facts of each particular case. For some, this may raise the question of how helpful the distinction between so-called acts and omissions really is. Can any omission not also be described as an action? And vice versa? The ratio. Although the elements of actus reus and mens rea must necessarily coincide to make out an assault, it is not necessary for the mens rea to be present at the inception of the actus reus. It can be superimposed onto an existing act, provided it was a continuing act. The order. The appeal was dismissed, and Mr. Fagan's conviction upheld. The end.